time, so I will kick things off and welcome everyone to the Connecticut Valley LERA presentation today, Hot Topics in Employment Law. For those of you who may be new, I'm Gail Winch and I'm the president of the Connecticut Valley LERA. And just a couple of quick announcements. Just a reminder to please renew or become a member of Connecticut Valley LERA if you like our programs. And to do so, just go to our website, which is CT Valley LERA, and you can become a member right there. In order to access the recording of today's presentation, you do need to be a paid member. So that is a pretty good incentive right there. And just to let you know, and as a reminder, our next presentation will be on December 10th, when Andrea Barton-Reeves of the Connecticut Paid Leave Authority will return and tell us what we need to know in order to start working with our employees who may have access to the Connecticut paid leave law starting in January. In fact, I think they can start requesting their leaves as early as December 1st. So this will be a very timely and informative presentation, and it will also talk about the relationship between the paid leave law and the existing Connecticut Family Leave Act. So that is not to be missed. And we are still planning our programs for the spring, so stay tuned for that. And then our usual housekeeping details. Everyone is muted to preserve sound quality. The program will run for about an hour. Mark has said that he'd like to hold all questions into the end of the presentation so that he can get through what he wants to share with us. And then if you want to ask a question at the end, either put it in the chat and I can ask the question for you, or you can unmute yourself. But we do want to allow time for questions. Like I said, the program is being recorded. It will be on our website. Mark is also making the slides available, and we will get those out to you, and along with your CLE certificate. Also, if you're joining by phone, we need to see your name so that we know who you are in order to send you a CLE certificate. So just rename yourself on the Zoom. And without further ado, I'm going to turn it over to our presenter today, Mark Sommaruga, partner at Pullman Comley, who is well known to us at Connecticut Valley LERA. And Mark, I'll kick it off to you.
Thank you very much. I'm proud of myself because I remembered to unmute myself before I started speaking. So we're already off to a good start. I'm going to put up right now, let's see if this works, our PowerPoint for the day. I assume that's on the screen for everyone.
Yes, it is.
Yeah, it worked. Oh, awesome. Let me just say, in terms of following this stuff, I do this for several reasons. One, I am the legislative liaison for the labor and employment law section of the Connecticut Bar Association. Number two, I follow this for our firms. My firm is Pullman Comley. Our blogs we do to follow this stuff. And three, I am a legislative nerd, and I maybe don't have much of a life, so I actually find this stuff fascinating. So that's why, for better words, I've been doing this for several years. So we're going to go to our very first slide. This was a unique year because if you just followed after what finished in the legislative session, the regular session of the General Assembly, you thought it was it was an okay year. It wasn't as significant in 2019 when there was some huge legislation passed. But then voila, within a week or so, there was a special session which dealt with the cannabis legalization issue in the budget implementer, the famous bill where you pass a bill to implement the budget and throw stuff in that may not necessarily be budget related. Together, there was over, I have the total here, 1,093 pages of bills, material between these two bills, which was fun for people like me who are trying to follow the legislative session. Anyways, enough of me whining. Let's start this right now. And by the way, as Gail said, please, you can use the chat function, write your questions down. I'll try to get to them at the end, but if you feel free to ask away if you think anything. The very first bill that was passed, and you can see I'm referring to Public Act 21-2. That 2 means this was basically the second bill that was passed by the legislature early on in the session, took effect back in March. And what it basically did is it amended it, I would say, not only the Connecticut Fair Employment Practices Act, but actually the entire Title 46A, which deals with public accommodations and other civil rights statutes, so that discrimination on the basis of race would include not only race, but also be, traits that are, historically associated with race. And there's a specific reference to hair texture and protective hairstyles. And furthermore, there's even a definition of what is a protective hairstyle in the law. You can see on the screen, wigs, head wraps, hairstyles, certain specific hairstyles are mentioned. And let's be blunt on this. A lot of these things in the past were a proxy for race. Again, when we analyze these kind of claims, that people would use this as a proxy for race. And this way, the law now is very clear in saying that these type of things, that racial discrimination includes these type of areas. I think this is a trend-setting bill. I think we may be one of the first states in the country to pass a Crown Act, which is the acronym for creating a respectful and open world for natural hair. So this bill, again, was one of the first bills passed. The next one is dealing with breastfeeding in the workplace. Took effect about a month ago. Now, there's a current statute that deals with the ability of an employee to express breast milk, in the workplace during a meal or break period. What this bill did is amended that current law about lactation rooms in the workplace so as to require that, again, subject to there not being an undue hardship. And, undue hardship is one of those famous phrases that allows people to, pay their mortgages if they're lawyers or get additional work. That there's additional things there must be that in this room, it must be free from intrusion and shielded from the public while the employee expresses milk. I would assume that prior to this, a lactation room would not be right in the middle of the workplace, but it's now clear it has to be shielded from the public, and also to be located to include or be near a refrigerator, or, as the law said, an employee provided portable cold storage device. I always would view that as a nice shorthand or longhand for a cooler. But anyways, an employer has to provide a refrigerator or cooler so an employee can store them express milk. And also you must have an electrical outlet in the room. Okay, the next bill dealing with the age inquiries. And it's an act deterring age discrimination in employment applications. I'll be blunt. A lot of this stuff is stuff that probably made common sense, or if you look at Equal Employment Opportunity Commission guidelines, prior comments, it would make some of the stuff was probably already there. But this makes it very clear in the Connecticut Fair Employment Practices Act that it is discrimination to require an employee to provide their age, date of birth, dates of attendance, or date of graduation from an educational institution on the initial employment application. So, a lot of people, I'll be honest, I was hoping most of the clients I work with, I would advise them not to require a date of birth. But now it's quite clear you can't require this. And also, a lot of times people who weren't requiring a date of birth were requiring people to list the dates of attendance or graduation from the schools they went to. Well, now it's quite clear you can't require that information. And again, that was probably commonsensible. Any ways to avoid a possible age discrimination claim? There are exceptions for where it's based on a bona fide occupational qualification or need. You can see where there may be at times when there's a minimum age requirement, or the information is required to comply with any provision of other state or federal law. Next, while we're in the world of Commission on Human Rights and Opportunities, this act concerns the duties and responsibilities of the Commission on Human Rights and Opportunities. One of these bills provisions, since 2019, the Connecticut Fair Employment Practices Act has had a 300-day statute of limitations as opposed to a 180-day statute of limitation. This extends that 300-day statute of limitations to all discrimination claims. To some degree, those who live in the world of employment law have already been here. There's another provision regarding the sexual harassment training that is now required, although some of these requirements have been delayed during the pandemic, that if an employee had received in-person training by the commission and this is again from the commission, either in person or through their online training program. If you received it from CHRO, while working for another employer, you don't have your excuse from having to get it now if you got a new job. In other words, if you've been employed by a different employer within the 2 years prior to date of hire, and you receive training from CHRO, you don't have to get it again. There's a couple other minor things in here about the CHRO public hearing stage, about the referee providing service and notice in terms of what they must provide notice of, the complaint required notice, what they must be provided by in terms of email, fax, or filing, transfer protocols. I'm not going to get too much into it. There also is a provision in here about state agencies, and I'm not sure if we have people there from the state here. Generally speaking, that in the past, if the state agency if there was a EEOC or CHRO investigation, a lot of times the internal state agency discrimination officers would put their investigations on hold. This basically says that that even if they rely upon a CHRO or EOC process instead of their own investigation, they still have an obligation to indicate incorrect discriminatory conduct. That seems pretty sensible in my eyes. Next is going to be prevailing wage, something that some of us here deal with the municipal. I represent public agencies, so I deal in municipalities. So I deal a lot of these issues about prevailing wage rates. But what this act did is there previously was a process for setting what the prevailing wage was for certain contractors, certain construction contracts that are covered by this. And the past used to be, I think, a hearing before the Department of Labor. This says that the prevailing wage rate will be those rates established in collective bargaining agreements, for the same work or trade in the town where the project is being constructed. You saw in my red font the word of historic. If there's more than one collective bargaining agreement, the question is which one do you follow for determining the wage rate? And what they had is a compromise. Originally, the law, the first version of the bill said the dominant collective bargaining agreement. Now it says the one of quote unquote historical jurisdiction will control if there's more than one collective bargaining agreement within the town for that specific trade or occupation at issue. To be honest, there is no definition of what that means of historical jurisdiction. So stay tuned if there's more than one collective bargaining agreement. The next one, I'm sure no one really cares about that, right? Public Act 2125. I think you probably all do care about it, knowing that we are the Labor and Employment Relations group here. This was the bill that was passed regarding in the aftermath of the Janus decision in terms of providing access to public employees for the unions. And the first part of it is generally the information. Right now, within 10 days of hire, public sector employers are supposed to provide to unions information about newly hired employees in a digital format of information such as the employee's name, job title, work location, I think telephone number, home address. Now, as of January 1st of 2022, this will be required now also for all current employees to provide this information and to update this information every 120 days. More interesting, this bill also requires employers to provide unions with access to new employee orientations. Now, here's the thing. If either party wishes to request, they must negotiate the issue of the structure and time and this access. And in the absence of an agreement, then either party may demand compulsory arbitration. And this law provides a specific process in terms of interest arbitration, something that's different that exists now in the Municipal Employee Relations Act, or even the Teacher Negotiation Act, in terms of certain factors that must be considered by an arbitrator. I'm not sure if there's been a single arbitration yet on this, but that's something that, since the act took effect October 1st, but you have a certain period of time. You must reach agreement within 45 days after your first meeting, or 60 days after the request to negotiate. Then the party has a right to go to arbitration. The bill also requires employers to provide unions with access to employees now, even during the workday. Now, and also access to government buildings and facilities. Now, it does provide specifically that you can meet with newly hired employees without charge to the employee's pay or leave time. That means without loss of pay. You know, it's basically you're paying the employer's paying the employee to receive this training. It's I think you have to provide at least 30, not more than 120 minutes of access for new employees within 30 calendar days of the employee being hired or during orientation. There's also provisions that allowing a union to expressly meet with individual employees on the premises during the workday to investigate grievances, discuss grievances, and to conduct worksite meetings. Now, the worksite meetings can take place, it says in the law, on or after the workday, before or after the workday and during meal period and other paid or unpaid breaks. It's not clear as to the meetings with individual employees, whether still be paying the employee to have these meetings, because it's not specified in the law. This may be an area of controversy that might take place of whether you're paying the employee. As they say, there's more. The law provides access to the employer's email system to communicate with members. Now, on the payroll deductions, basically, the union's supposed to provide a certification that it is maintaining the authorizations, because you're supposed to receive authorizations. As always, you're supposed to provide. Employees supposed to provide authorization, withhold dues. This has the union maintaining those authorizations, and that the employer must rely upon the certification by the union that it has these authorizations, unless a dispute arises about the existence or terms of these authorizations. The bill also says that employers are supposed to direct any employee request to cancel or change their deductions to the union rather than the employer. In other words, the employer has to stay way the hell out of this and basically, direct the request to the union to deal with this. And the law specifically says that any deductions may be revoked only under the terms of the employee's written authorization. Now, that might be, I'm not going to speak out of turn here. Maybe it may provide 30 days notice. There may be a specific provision in the authorization, but that's basically that would control if someone were to seek to revoke their authorization. The bill also specifically prohibits, I think this is pretty much a given, that you can't deter or discourage employees from union membership. It makes it clear that it'd be unfair labor practice complaint. I assumed it would be one anyways, but now it's specific in the law. It also prohibits an employer from allowing any entity to use the email system to discourage membership in public employee organizations. So we're required to provide access as an employer to the unions, but we can't provide access to any entity discouraging membership in a union. There may be some constitutional issue with that. I will not comment any further on that. You can see there's a lot here in that bill. The next one I'm going to talk about is an act that took effect on October 1st about salary range. We all know about the current law that prohibits employers from asking an employee or an applicant about their prior salary issue. Well, this amends the law that requires employees to disclose the job applicants the salary range for vacant positions, either upon request by the applicant or by the time that an offer of compensation is made. And also, you must provide a wage range to an employee upon a position change. Now, it defines what you may ask, well, what is a wage range? How do you define that? It means the range of wages that an employer anticipates relying on when setting wages for a position. And it may include a reference to a applicable pay scale, a previous range of the position, the actual wage for the people that are now hold the position or currently hold the position. The law also amends the Equal Employment Equal Pay Act by requiring the provision of comparable pay for comparable work instead of equal pay for equal work. We'll see what that means going forward. Next, here we have a bill about workers' compensation and post-traumatic stress disorder. And there's a current law. The current law prior to this change provided workers' comp benefits for post-traumatic stress injuries to certain professionals. It was police officers and firefighters, and I think parole officers who witnessed certain traumatic events such as deaths or maimings. This extends this to, also EMS personnel, Department of Corrections employees, not just parole officers, but all Department of Corrections employees, and also telecommunicators. This law also covers healthcare, provides this, covers post-traumatic stress injuries to healthcare providers involved in responding to COVID-19 and who witnessed death or traumatic physical injuries linked to COVID-19. So this is a little bit of an exception that's kind of occasioned by the pandemic. Also, the phrase now, instead of using the phrase post-traumatic stress disorder, now use the phrase post-traumatic stress injuries, which could be a bit broader. Unemployment compensation, this basically, it kind of says what it means, and it means what it says, that this removes COVID-19 related layoffs from the unemployment compensation experience account, basically for the period of this period of time through the pandemic. So I won't spend too much time on that, but this took effect October 1st. Department of Labor operations. A couple parts of the first bill, Public Act 2198. First of all, as it actually in the title says what it does. It says the executive director of the Employment Security Division shall be the classified service, and it'll be a full-time position. Second of all, very, very important stuff. I say this because if there's arbitrators watching or listening, that this increases the compensation for members of the State Board of Mediation and Arbitration to $325 a day for each day beyond the first day of hearing, and $200 a day for each executive panel session. And I'll say point blank to all the arbitrators listening, you're all worth this money. You're all worth more than this money. And I collectively love you all. Just remember to rule in my favor. Just kidding, for the most part. Also, there's a Public Act 21-18, which has many things about the Workers' Compensation Act, but it changes the title of Workers' Compensation Commissioners to administrative law judges, which may sound better or more important. This is an act, Public Act 2143, dealing with prevailing wage projects and energy projects. And it basically says that developers of certain renewable energy projects, and there are certain exceptions in the law, those selected before January 1st, 2022, to meet the prevailing wage standards. If the project began after a certain day, which is July 1st, 2021, and has a certain nameplate capacity rating of 2 megawatts. I'm not an electrical expert, but this basically extends the prevailing wage law to certain these energy projects, and it also requires a community benefits agreement for certain projects too. So next, disparity study. This is a special act, and it requires CHRO along with Department of Administrative Services to issue a request to study proposal to conduct a disparity study for the reason of determining whether the state set aside programs that they have, affirmative action programs, whether they're meeting the current goals of encouraging participation of small contractors and minority business enterprises. So it's supposed to secure a request for proposals to conduct a study. I assume once the study is conducted, it'll lead to some kind of action. The cancer benefits for firefighters, there's already a new program that was put in place, I believe it was a couple of years ago, but now this establishes a task force to study whether the current program is adequate, and also more importantly, whether it may be worthwhile to make this a workers' compensation benefit for these types of injuries, for cancer-related benefits for firefighters, specifically occupational exposure to fumes or poisonous gases. And they're supposed to report back to the legislature by January 1st of 2022, and there may be some legislation whether to include it within the workers' comp, these type of benefits. This is a big one about layoffs and recalls. This originally was going to be a much broader bill, which would have covered basically every private sector layoff, but now it's been limited to certain employers, food services, contractors, lodging, kind of in certain industries, service industries for food services, and also building service enterprises. If you have at least 15 employees, to notify basically to within 15 days of a layoff. And this is for layoffs within a certain period of time, March 10th, 2020, which is the time the pandemic hit, and May 1st, 2022, regardless of the reason about available positions for which an employee is qualified. And I'll just say, the first thing that hits people's mind when you look at this is this looks a lot like, when you see these slides, something that would be in a collective bargaining agreement. The ideas of layoff notices and recall, but it's now spreading this to these specific industries that an employee has a right to a recall if they've held the same position or a similar position at the time of their separation, or if they could be qualified with training. And this provides that employers shall be offered a position in order of preference. Obviously, number one, if you held the position before; two, if you could be trained. And guess what? If you have more than one employee entitled to a position, it goes with the person with the greatest length of service at the employment site. Again, that looks a lot like a collective bargaining agreement. And it also requires that it be in the same classification generally. Same type of, same classification, same work site, same duties and compensation. Again, very collective bargaining type. And it provides that it gives that person a right to work in that position for 30 days unless there is just cause for the termination. Again, another example of collective bargaining agreement provisions being kind of extended to this type of these industries. And also it did allow those with COVID, who had COVID, that was contracted prior to May 1st, 2021, May 1st, to have a right to accept the position until the end of the state of emergency, which we're still in, by the way, at least until February. And it says if you hire someone other than a laid off an employee on a basis of lack of qualification, you must give the employee written notice identifying those reasons. You're also required for those industries to provide notice of 30 days after any layoff, giving the reasons for a decision on a layoff. In addition, this bill, surprise, surprise, guards against retaliation, provides a cause of action if you do retaliate against laid off employees. And it contains an exception if there's been a change in ownership of the business, or a change of their organization, or if an employer moves their operations more than 25 miles. It also provides that provisions may be waived by a collective bargaining agreement if the waiver is clear, and it will not invalidate provisions of any current collective bargaining agreement or contract that provides for greater protections. That's a mouthful. Last, but as we get toward the end of the current session, the Second Chance Bill, there's a long title for this. Basically it's called the Second Chance Society legislation. Effective January 1st of 2023, the employment provisions are pretty clear, making it a discriminatory act to deny employment based upon a person's erased criminal record. I'll just say original versions of this bill went even stronger in preventing any limiting greatly reliance on criminal records, but this is limited now to erase criminal records. Guess what? This was a very special year in Connecticut because we had the special session of the legislature, and a few things happened. First of all, cannabis, weed, as some people call it. First of all, a lot of these employment-based conditions generally take effect July 1st of 2022, and it provides that that you are not required to make accommodations for employees. You can say that you can't perform. An employer could still say that you should not perform your duties while under the influence. And also you can generally you could still, as a matter of law, as an employer, ban the possession, use, or consumption of cannabis while performing duties. and on the employer's premises. There's exceptions for possession for those who possess medical marijuana. However, to be very clear, any employer policies regarding prohibiting the possession, use, or consumption of marijuana must be in writing and made available to the employer prior to any employee prior to enactment. And you can only take action against an employee pursuant to such a policy. And this applies to not only on job, but also off-duty conduct. So that implies you can still prohibit off-duty possession or use of marijuana under certain circumstances. However, that would be for, again, discipline for outside the workplace conduct after you hire the person. There are limitations upon whether you can rely on that for that conduct prior to the person being hired. So in other words, if you're an employer, your employer is someone, if someone had been using marijuana outside the workplace prior to them being hired, there's limited circumstances when you can discipline them to that pre-hire off-duty conduct. This bill, however, exempts large classifications of positions. For example, those positions like education, law enforcement are exempted from this. So the usual rules are still in place. You can still have the same right to have a drug-free workplace in general and conduct drug searches and tests. But obviously there's limitations on the use of the positive test as a basis for discipline. There was something also thrown into this bill about smoking, that you can ban it anywhere in the workplace and also within 25 feet of a doorway, window, or air intake vent. So it's expanded that you could obviously have a smoke-free workplace, but you also have to ban it. In other words, people lighting up outside the doorway of your business, anyone's business, have to be 25 feet back. The big bill, the implementer, yippee. Again, it's called an act implementing the budget, basically, but it has a lot of things that are not budgetary related. That's a common habit. Drives me crazy, but that's the way things are. 790 pages of joy. Boy, it was fun to look at. Several related provisions. There have been many bills over the last 3 or 4 years proposed about domestic workers. And what this one did is the very first bullet point. These are longstanding concepts that had been in place about requiring an employee to provide certain notice at the time of hire about their rates of pay, conditions of employment, ability to have leave, whether they have access to leave, unpaid or paid, not, just whether it's available, not without requiring it to be provided, and whether they're going to be charging any fees for lodging, and also how to file a complaint of a violation of these provisions. This also requires, this is new compared to the prior concepts that were put in place. They were discussed for years. It requires the Commissioner of Labor to establish a domestic workers education and training grants program to provide grants to certain organizations. And I think one of them is the Yale Law School, to provide education and training to domestic workers on their rights, so they understand that they can exercise their rights under that first bullet point, and also to provide online resources for domestic employees and employers. I put this up here just in case people want to know, and you'll see it on the slide, what is a domestic worker covered by this law? And as you see here, it includes includes those, does not include employees providing babysitting services on a regular intermittent basis, and doesn't not include personal care attendants and providing services pursuant to state-funded programs. And I list here the type of state-funded programs that are exempted as personal care attendants from this law. But obviously the first bullet point indicates who is included as a domestic worker, as in terms of providing domestic work on or about a private dwelling, housekeeping work, laundry, meal preparation. So these things are covered by this new law. Next, call centers. This is something that's been discussed for years as well, in terms of covering this, in terms of banning or limiting the ability of call centers to relocate. And it just says that in terms of providing notice, you must provide 100 days notice if you're going to move to another country of the relocation. Originally, the law version of the law I saw said you had to give 100 days notice if you're going to move out of state. Now it's just to another country. If you relocate to another country, you are ineligible for state grants and funds. And also, if you do so, you have to remit your back. You basically got to pay back the money you received in the previous 5 years. There are exceptions if it would threaten national security or result in job loss to the state. So these are general requirements about call centers. There's also now a general requirement that state may only contract with in-state call centers. FMLA, an unpaid FMLA. This bill requires the paid FMLA Leave Insurance Authority to begin repaying funds from bond authorizations. This bill also requires, actually, it used to require the commission, the law used to require the Commissioner of Labor to conduct a hearing for persons aggrieved by a denial of paid leave. Now this law will instead permit the Commissioner of Labor to conduct a hearing. In other words, a Commissioner of Labor, when facing a claim about a denial of paid leave, could decide a case based just upon a documentary record. It also eliminates a provision that explicitly excluded the state from being an employer covered by the state FMLA. And also it provides that, and this would cover non-bargaining unit members would now be covered by the state's FMLA, the Connecticut FMLA, as opposed to the federal FMLA. The law also provides, this is kind of similar to the merit assessment process that exists now for the Connecticut CHRO claims, that there's an investigatory phase for FMLA violations that they can be dismissed without before having a hearing based on a review of the record. And also subjects claims of violations of FMLA, the state FMLA. And this is in addition to the paid FMLA, there's 180-day statute of limitations. Okay, unemployment compensation. A few things in the bill. Requires the Commissioner of Labor to establish an office of the unemployed workers advocate within the Department of Labor to assist unemployed persons with filing unemployment compensation claims, assist them with their basic stuff. Now there's an advocate within the Department of Labor to help people with unemployment compensation claims. It also requires employers subject to the unemployment compensation laws to provide certain data. Having here a problem with my PowerPoint here. Hold on one second, folks. It worked. Let me go back one here. Okay, task force, my favorite thing. I always make fun of this and by saying that maybe there should be a task force to study task force. This first one provision, this is again one of the many provisions of the implementer, requires CHRO to conduct equity in government programs with respect to various protected classes, also not only the ones that are generally thought of, but also areas of geography. Study, again, whether there's equity in state government programs. We're supposed to hire a consultant as part of the study, and the study specifies whether one thing to look at is these inequities have been worsened during the pandemic, and also requires a report to the General Assembly by next year, 2023, which is the year after next year. It also establishes a task force to study the state workforce and retiring employees, basically to deal with this, the issue of the silver tsunami, the idea that certain managerial and exempt employees are eligible to retire, that there may be issues in executive branches in preparing for these retirements, and also the study of the areas that there's barriers to the recruitment. This is something that has to be reported back to the legislature by January 1st, 2022. To study these issues, because we could have a major problem in government. New workers' rights and protections. One of these is basically the part that not unclassified or non-union state employees are now have to be given the same rights and benefits provided to those covered by collective bargaining agreements. There's another provision in the law, interesting timing on it, that basically says employees, if you get 2 hours of unpaid time off, starting now through June 30th of 2024 on dates of regular state elections, and basically for state officers and federal officers, the even numbered year elections, so they can vote if they so request. If they provide 2 days working days notice, you must provide the 2 hours off, assuming that it is time take if they're working between 6 a.m. and 8 p.m. the hours of the election. Assuming that's the case, they can get 2 hours off to vote, unpaid time off. Now it expires June 30th of 2024, so on its face, it's going to be kind of a pilot program next year to see how things go with next year's state and federal elections. The bill also expands the non-retaliation provisions regarding workers' comp claims. Do not only prohibit people from, in terms of retaliation, but also from deliberately misinforming or dissuading employees from filing claims for either workers' compensation or the new Connecticut Essential Workers COVID-19 Assistance Program. That's called an unintentional segue, because now there is a Connecticut Essential Workers COVID-19 Assistance Program to provide benefits for lost wages, out-of-pocket medical expenses, and burial expenses for certain essential employees. And these are defined as the employees that are listed as phase 1 and phase 1A and phase 1B of the vaccine program, for those who could not work due to contracting COVID-19 or symptoms like your diagnosis COVID-19. And it's supposed to cover those essential workers who died or could not work due to contracting COVID-19 between March 10th, 2020 and July 20th of 2021. Again, that's the period of time that's sort of in play. Or those who contracted COVID-19 that was confirmed by a positive lab test or diagnosis. And also there are certain exceptions for this that they did not, that if you specifically, if you had worked, obviously if you worked solely from home with no physical interaction with other employees before the inability to work, you're not eligible if you worked 14 days prior to this from home, or you received a written offer or directive to work solely from home, which chose otherwise to work on the work site, you would be ineligible for this benefit. So this is benefit you must apply for. And it's on a first come, first served basis. It's on top of the workers' comp benefit. And obviously there's a set off if you get workers' comp benefits for COVID-19, there's a set off from this. You can't double dip. This bill also it increases the workers' compensation benefit, burial benefit, from $4,000 to $12,000 for future annual indexing for inflation. I'll just say on the Connecticut Essential Workers COVID-19 Assistance Program, I wrote a blog post on legislation on this that's on my website or for my law firm, Pullman Comley, that goes into greater details of this COVID-19 assistance program if you want to have more information on it. Most important slide now, as we come here to the 3/4 way point of my presentation, is my unfortunate picture. Seriously, folks, if you have questions, I'm all ears. So let's go to the chat room. Are there questions?
Hi,
You're
everyone.
Come on, people.
Yeah, that was,
Ask
first
away.
of all, that was an amazing presentation, Mark, with the amount of material you covered in 45 minutes. And I was sitting here thinking, oftentimes people think, what the heck does the legislature do? Whether you agree with what they've done or not, certainly they did a lot this past year. And there's a lot here for employers and union delegates and HR professionals to stay on top of. I can tell you that one thing that we've been dealing with from our HR group is the age, the requirement that we can't ask about people's ages on applications and like what years did you go to school and things of that nature. And on occasion, we have heard back from the vendor who does our background checks about trying to verify the years that somebody attended a particular university or college. And I'm assuming that it is permissible post-conditional offer of employment to ask that information.
Yep, and that's very key. The statute says the initial employment application. I would take the position that that's the key phrase, that after you have, the offer has been made, I think there's nothing preventing you from using this information. You could also argue there may be circumstances where if you need to verify it, I would argue there may be a bona fide occupational qualification or need. I mean, if you go to the application itself, but I don't want to go, that'd be too much of a jungle to jump into. But I think clearly at a certain point in time after that initial application, once you've made the offer, then you can plunge into it. I think the idea is to make sure you make the offer. You're not conditioning, you're not refusing to hire people based on their age. But I would assume, based on the very wording of the statute, that after you've made an offer to hire, if you need for a compelling reason to verify someone's employment dates or college dates, or actually let's put it this way. If you need to verify the person's not lying on their application, and I've been involved recently in a high profile case involving an employee who lied profusely on a resume, this might be I'd argue that you have the ability still to protect yourself. I want to hear from people because I see the group of people on this call, because I'll put it out there. I represent generally public sector management. So I come with a pseudo, bias here. I see there's a bunch of people here from the labor world.
Yeah.
And which I respect completely. You're all lovely human beings. If you have a take here on Public Act 21-25, something you agree with or disagree with, I'd be curious of your views on the employee access or the union access, because I think the law is pretty clear about the ability for the new employee orientation or a new employee to visit, for up to 30 minutes to 2 hours for an initial meeting with the employee, where basically, without being too wise, the employer is paying for you to train us your employees to file grievances against us. But after that takes place, if whether you feel we have to pay the employee, for example, if you're an employee and and a representative is investigating a grievance and is meeting with an employee, and you're meeting with the employee outside of, not outside the workday, not before or after, or not during a break, but during the workday, what your view is, whether it's our obligation to pay while that employee is meeting with the union rep. I'd be curious to hear people's views on this. I'd be curious to hear anyone, again, it's early on, the experiences people might have, because to a large degree, as I said, the bill is putting a lot of trust. It's giving the union the power, while the union's indemnifying the employer, and a lot of collective bargaining agreements already provide that. The union's now holding the information, the authorizations. A lot of degree of trust there. Have there been any issues anyone's had on implementation of 21-25? So with that invitation for people to ask questions or make comments, someone please do so.
Yeah, please unmute yourselves.
We can come back and we'll find you if you don't speak.
It's a safe
Someone.
space, I promise. Hey, Eric.
Hi, I will say that in bargaining, we've had employers, I represent unions, obviously. We've had employers take the position a couple times that they want to see the actual cards, the dues authorization cards, as opposed to just having the union produce a list and certifying that the list is accurate and confirming that here are the people that we have signatures for the dues authorization. And we've pushed back against that, as you can imagine. And I think it probably isn't in the employer's interest to try to maintain dues authorization cards. And I think if you have the hold harmless language coupled with the language that the union is certifying that these are our dues paying members, think the employer should be satisfied there.
Yeah, I'll just tell you, Eric, my experience after Janice was I didn't want to get involved in any of this as an employer. And I would used to always say, don't talk to us. I would usually say, I mean, the old line was, if someone had an issue, don't talk to us, talk to either your union or talk to the Department of Labor. We used to throw that as an alternative. It's not mentioned now, the Department of Labor, but just someone else discuss it. And I agree that we don't have an inherent right to look at it unless there's been some kind of dispute about those authorizations. I mean, I think that's clear in the law. So I think an employer would have to have at least some colorable basis for wanting to look at them. So darn it, it's not cool when we agree on these things. Come on, someone. Say something controversial, somebody.
Mhm.
But I agree, seriously, Eric, I don't want to get my clients involved in these things. I mean, in a selfish way, the pre-Janice world was a lot easier for my clients.
It was better for us too.
Surprise. I was surprised one thing, though. I'll comment on this, that I thought there'd be some provision in the bill when they 21-25, because unions are in a position now where they're kind of, in terms of what we call the freeloaders, having to represent their interests. And I thought there would have been something more direct in the bill about, the idea of being direct in the bill about a union not having to process grievances, for example, of a person who's not a dues paying member. I thought that'd be in there.
Yeah, I think that would have invited litigation.
Yeah.
Yeah. Yeah.
Or at least charge something. I think a union could, in theory, I'm not sure what you're doing now in terms of after Janice, but in theory, you could develop a service fee, an optional service fee that non-union members could pay for certain additional services, a la carte services.
We should probably move on from that.
Are there
No one else is
other...
volunteering, Eric. You get picked up. Thank you, Eric, for speaking up, though. Anyone else want to speak up? Let's see.
Yeah. Any other questions? There was so much in Mark's presentation.
How about, I'd be curious, Joe complaints filed based upon the protective hair statute. Anyone had one or been involved in one?
We have not. It's interesting. I do think more and more, I feel like more states are passing laws of that nature as well. I know I believe New York has a similar law. So I think we're going to see more of that, although it may depend upon how some state and federal elections go over the next year or two.
I'll say this now on the salary range statute, I heard this question. There's nothing in the law that says you must put on a job posting the salary range. Obviously, if an applicant asks for that information, they get it. And if an offer of employment is made, they would get it by nature, but it's not required to be on the posting itself, although some employers just have done so.
Yeah, I think that was a tricky one for us to navigate as well.
And I was surprised on the breastfeeding one. The breastfeeding statute, the idea that you had to put in there that there must be shielded from the public, because I say this as both a employment lawyer, but also, my son's 11 years old. He's not 100. So I remember very clearly those times 10 and a half years ago or so when we had to deal with these issues. So for my wife. So some of this is common sense, but again, I see why you want to put certain things in here, such as the access to electricity for those who may have a pumping machine or stuff like that. So.
Well, and I also think that there's some anecdotal evidence that employees are just saying, just use the ladies' room, and that's just not an appropriate place. So.
Yeah, I think that was clear. And I thought my wording reading the statute was ladies that a restroom would not have been appropriate, but now it's crystal clear. So
Yeah, I always find some of these laws to be very interesting, and I think, well, what was really prompting the legislators to bring some of these these acts forward? Because you're not necessarily hearing about issues in the media, but obviously they have some constituents that have some needs, and they try to deliver.
I hope there's no legislators on the call, but part of it may be that they can, when they send their mailings home to constituents, can say they sponsored a bill that passed.
Exactly. Anyone have any other questions for Mark? Like I said, he's graciously allowing us to distribute his slide deck. I'm sure he'll be available for questions for his last slide. And I'll just give folks another minute in case there are any questions. I know it's a Friday. People are looking forward to the weekend. It should be a nice fall weekend. And Mark, I'd just like to thank you very much for your time and the work that you put into putting this presentation together.
It was my pleasure. For whatever reason, I find it very interesting time period when the legislature starts in session, because there's a flow to it. There's the first month you don't pay attention at all, especially in a long session, the odd number of years. It's a little bit less of a time because next year will be shorter. Then there's the committees, which is very fascinating. The most frustrating thing is the implementer, when you have things that didn't even get a committee hearing, suddenly it's thrown into the bill and you're having to try to make sense out of it. So,
yes, wonderful. Well, thank you everyone for attending. Thank you again, Mark. Thanks to our colleagues from our National LERA who host this program for us. And like I said, we will put the information about the December 10th program on the Connecticut paid leave law. That will be up on our website probably next week. So please register for that. And we'll see you then. Thank you, everyone.
thank you. Thank you.
Take care now. Bye-bye.